Hexico, what's happening? Back on AirPods. Mike still died. Can't do anything about it. It's like I don't even think it's 6 months old. I think it's like 4 or 5 months old. But we're gonna do the show. We're gonna do it. We're gonna do it live. We're gonna do it live. Okay, don't worry. Hexican, ladies and gentlemen, we got a very nobleman back on the show. We got Nuclear Herbs talking about all the SEC update stuff. I just watched Corey's show, or watched part of it yesterday. I didn't even know they did a show. About it. So that was a really good one too. And I was like trying to prep for this one. But anyways, we're gonna get into it. Put all your legal, SEC, all those questions, and I'll get to the moment. Without further ado, welcome back to the show, Nuclear Herbs. How's it going, sir?
I am doing great. How are you?
Doing amazing. Still got some sunshine outside, and I get to go on stream with you and talk all this amazing stuff that nobody understands except yourself and a select other few that comment on it from time to time. So doing well today, doing well.
All right, that's good to hear.
Yeah, as I was saying, I literally was like, oh, I didn't even know you streamed with Corey a couple days ago. Even when I talked to you about it, I didn't even know. And yesterday I was taking a walk and I was listening to, trying to catch up on some of the conversation there to get more of a context for today's conversation. But yeah, it's lately we've got some new documents, some new stuff come out, and a ton of them. I'm not sure. Have you got to go through a lot of the stuff yet? I've read the original Motion to Dismiss, but this is like another chock full. I'll bring it up on Twitter in a moment. Just a ton of more stuff to go through, exhibits, a lot more in favor or to support the case, to Richard's case. Is that right?
Yeah, that's right. We knew initially, like in April 8th, when Richard filed his, he didn't file it because it's just a court rule thing, but that brief was leaked onto the internet, so we all got to see it back on April 8th. What we didn't see is the exhibits that went with it. So, we finally got to see those this time around. And then, then the way that motions work is you file a motion, somebody files a response, and then you get a reply. So whoever files the original motion gets the last word in, which is, that's just kind of the way things work. So, we got to see it all pretty much on one day, which is really unusual. And to be honest with you, not a lot of fun because that's way too much reading. I would rather have that spaced out over the course of, a couple of weeks or so. But yeah, and then normally, like I've said before on other streams or, with other people, talking to other people, in federal court, you just don't have a briefing schedule this long. I mean, typically you see a brief filed or motion filed, and then, within 14 days or whatever it is there, you'll have a response brief filed, and then, another 10 days or so back, you'll have a reply brief filed. I don't know if that might be Arizona's timeframes, but I didn't do that much work in federal court, but so it might be Arizona. That's what I did almost all my work in, is local superior court in Arizona. But that's basically the idea. So you typically have a motion briefed up within a month. You don't normally have people asking for 3 months to write something, 3 months to respond to it. This is just such a weird situation. And then, and then not being able to see it. Like if you go to almost any case on Court Listener and see how motions get filed, they don't work the same way. This is the only judge I've ever seen that, makes you wait until it's fully briefed until you file it. So it's a little weird, but yeah, we got it all now, so we're good.
Yeah, it's I think we're like six weeks or so away, 6-7 weeks maybe, away from the October, the big date and stuff there. Is this
exciting?
Is it? Yeah, very exciting. To the New York meetup. I know that I think PulseChain Tour is doing a meetup and stuff there as well. And a lot of people plan to go. This leading up to that, like, what do we know? I guess maybe we could just start with a couple interesting things we could learn from. I mean, these exhibits. I'll open a couple, and we can, if there's any you want me to select that you can think of to, just feel free to let me know. But in leading up to that, do you think having this information available and just us knowing about it, is there any key insights we can see of like, whoa, this is like anything that strengthened the case, anything that we didn't know before that's like, wow, this is they put in new documentation, or you were surprised by Richard's legal team putting this in because to support this particular thing. Anything you want to riff on to start there?
Yeah, let me just say that and I put this in a PulseChain Law School tweet, but the tone of the briefs typically gives you a lot of information as to what the parties think about their case. In this case, I read, if you read just Richard's original motion, memorandum of law, they're very confident. They state their position. It's clear. They button it up. And it's basically right there, leading the judge down the path where they want her to go. When you read the SEC's brief, they were forced to change up a few things from their original complaint, and don't forget the whole purpose of a motion to dismiss is all you're doing is attacking whether or not the complaint states enough to allow you to proceed. It has nothing to do with truth or facts or anything like that. This is just, did they put enough in the complaint to allow them to proceed through discovery and into summary judgment or trial? So it's basically a pass-fail test as to whether or not the judge thinks that they pled. It's called pleading it correctly, whether or not they pled their claims correctly. But the SEC, as Richard noted in his reply brief, like the SEC abandoned the alter ego argument, which was retarded in the first place. I did a PulseChain Law School class on that because it was just dumb. But calling software the alter ego of a person and then suing software, made no sense, from any legal standpoint. There's like zero potential to do that. I don't even, yeah, there you go. I just don't even understand how they even decided to press play on that in the first place. Richard's team this time, when they filed the motion and the memorandum, we got to see a lot of the exhibits. And when you file exhibits in support of your motion, you're expecting them to help you prove your claim, right? So I need to go back and watch those entire, he's got the links in them, luckily, because I don't want to read transcripts for a living, but one of these days I'll have to go back through and just watch those three and see why, what exactly is in there that they think they can help their client with. I know that in the, with the last three exhibits, one was the Hex white paper, one was the PulseChain sacrifice information, and the other one was the PulseX sacrifice information. I think it's like D and F or something like that, maybe. Or is there a G? It's probably D and F. But
I see numbers, like 1, 2, 3, 4. Oh, I bet inside of that it'll say letters. Okay.
Yeah. So.
Exhibits. So we got exhibit C. You said D, E, and F, maybe.
Let's see. Yeah, let's see E, F, and G, maybe, or whatever. 5, 6, and 7. Let's see what we got there.
C. The open 6. 6 would be exhibit F.
Let's see what we got there. There we go. Actually, this is the one I was looking at through this again, I think yesterday, and with an eye towards what exactly what is Richard's team trying to convey, with this? Because it wouldn't be there if they didn't think it helped. So, one of the, what's the issue that they're really trying to push in this entire motion? And it's personal jurisdiction over Richard. So in order to grab personal jurisdiction over Richard and drag his ass into New York from Finland, they need to essentially show that he targeted, U.S. citizens, or did other things to reach into the United States specifically, not just globally, but you have to specifically target U.S. citizens in order to, have personal jurisdiction law apply to you, long arm statutes and things like that. And I looked at it and I'm like, was there anything specific to the United States in there? And the answer is no. That's a good, what you're at right now, some countries, right? I mean, he doesn't specifically talk about any particular country in there. He does everything in UTC, doesn't do it on Eastern time or anything like that. He made a very clear statement in there that the PulseChain sacrifice ended on a specific date. I think it was like the August 3rd, if I'm not wrong, of 21. But the SEC is out there, in their brief talking about, there you go. Yeah. Talking about how Richard's promoting this in 22. Yes. So what? Like, I mean, if it doesn't have to do with the initial offering, which is the issue here, if it's a security, this is the initial offering of it. I still don't believe it's going to be it's going to be considered a security in the end. But hey, Zenith, nice to see you. I mean, you don't get to say. I guess you can't just run around saying like, no matter when he talked about it, after all the money was collected, now he's promoting a security. I mean, it's a little silly. Like the SEC's case relies on stretching a timeline well beyond, I guess, well beyond, like, it doesn't make any sense. I guess they're just saying everything you do, no matter what time frame, is relevant to the issuance of the security. And that just doesn't make any sense from an objective standpoint. So I'm still trying to figure out why they're doing it. And the only answer I can come up with is because they don't have anything else.
Yeah, it kind of feels like this whole thing is, there's just a bunch of things that they point to, but they're all either explainable or just not accurate, or just don't have anything to do with being a security. Or you could clearly make, at least we could say, you could clearly make a case. I was listening to you and Corey talk about it yesterday. I think you mentioned, like, you can make a case either way, but definitely, what we hope, right, is it's super easy and to make the case of, like, obviously not security, everything was done properly. There was nothing, not your money, one sacrifice, not targeting Americans, no jurisdiction. That case, you could, that's what they're trying to make here, right? They're trying to show, oh, here's all of the stuff. Yeah, you have all the data. You went through all the stuff. You're making your case. Well, here's our case to show that we did it the correct way.
Right. And then if you notice, nothing in the SEC's response brief prompted any changes in Richard's reply brief. Like, the things that he started out with, his counsel said X, Y, and Z. The SEC had to change some of their position, but nothing that the SEC said in their brief required an alteration or a change in anything that Richard's brief initially said. They just got to basically pound back at them and say, no, we're not moving off our position because we're right. And this is exactly what we said the first time around. We're saying it the second time around because we're still right. So, and that's a confident group of people who, when you can do that, you know where you are, exactly what your position is. They're just what they're trying to do with this motion to dismiss, is obviously get Richard out of it the easiest and fastest way, because that's the best result for your client. But they're trying to give the judge a big giant off ramp from the freeway that she's on. And, it's good, right? You just passed the sign that says, next service is, 200 miles, right? Like, and then you're like, oh shit, there's a big giant off ramp here with a bunch of, hotels and food and everything else like that. And I'm like, this looks pretty tempting. I can drive off of this and justify my decision to get off here. So they're giving her every reason to take the off ramp. And, and I think I said that, I don't remember when or to who, but this is one of those cases where if I'm deciding jurisdiction, I can read facts both ways. I can look at it and say, I can look at it and justify denying the motion. I can also look at it and justify granting the motion. And I think that would be upheld on appeal either way, depending on how I write that opinion out, because that's a fact specific thing, and courts of appeals, only overrule judges basically on law, on legal grounds. But if I find certain facts and apply the law correctly to those facts, whether or not the facts are accurate, it would still get upheld. So I think they're just doing their best to give her the facts that would justify a dismissal, which I think would be upheld again on appeal if the SEC tried to appeal it. So.
I was just searching for the SEC's response, and I came across this on Google too, which is, it looks like just a comment on the case. Pretty recent. Oh, I guess it's back in October. I was thinking this was more recent this year, but I just want to ask you real quick on the different comments and people that are writing this. I know we have the amicus brief and so on too, but do you think that, maybe a lot of people show up in October, how much of the community putting out the comments, putting in their, saying, signing amicus brief, showing up to court, what can they, just want to remind everyone what they can do to help support saying, hey, so I fud my bags, let's see, this is, it's my founder, this is my bags, this is, obviously these things are baseless, this was just baseless allegations against Richard Schuler and Innovative Products, passes the Halley test, all this stuff. How big a factor does that have on judges and courts and stuff like that? Can people really, help in that way?
I think the answer to that is yes, and I'll give you a good reason for it. When Marco went to the hearing in whatever it was, April or something like that, he had an opportunity to speak with one of Richard's counsel at the end of the hearing, and that guy suggested, hey, if a bunch of people show up in October, it's good for us. So why don't you see if you can, put it out there? And so I reached out to him as well and said, basically, what's the courtroom situation? How many people can we fit in there? And what's the, is there an overflow courtroom that could be used, and those type of things? And he said, yeah, if the courtroom's going to hold 50, most judges with most motions to dismiss they're argued in front of an empty courtroom. There's not even most of the time the parties aren't even there for these types of motions. It's just the attorneys and the judge and the clerk and the court reporter. So if you see somebody sitting in an aisle interested in a case, it's unusual to begin with. If we pack that room, that's going to be really unusual, because this judge has done enough cases, with government agencies, SEC and others, to know that we're not there supporting the SEC. Nobody goes to a hearing to support the SEC, right? She's going to know
waving the SEC flag.
That's right.
Waving Hexaco flag, maybe.
She's going to know right away why we're there, and and it may very well be, and I'm going to probably put this out 2 weeks or so. I'll put out a tweet maybe 2 weeks or so prior to the hearing, and just ask people where they're coming from. Are they going to be there, and what countries they're coming in from? Because if there's any issue with, well, look at all these Americans who showed up in the courtroom. Wouldn't it be great if I could tell? I would pass that information along to Richard's counsel and say, hey, bro, you got a seating for 50, and I have responses from people from 30 countries that are coming in. So, maybe, I might, if it were me, I don't know. I might announce that if that was relevant to my client's jurisdictional argument. I'd be like, hey, judge, wow, everybody in this room is, from another country. Americans make up a small amount, and that's because most of them here live in New York and showed up.
30 is 29 more than America. That's true.
Right. I would just think that would be an interesting and, possibly very significant memory for that judge when she's making a decision on jurisdiction.
Yeah, I was watching a documentary recently. It was about boy bands and stuff, and they were talking about what was the case with was it like Backstreet Boys manager? I forgot his name, but famous case. And the judge, I remember the relevant part to it is like the judge was like, he was basically arguing like I'm the band, like they're not the band, like I'm the manager, like I own all the stuff. It doesn't matter, the contract's not fair, all these things. And you have the band, standing over there too. And the line was around like, well, my teenage daughter has a poster of these of these boys on the wall, so therefore like they own their stuff. They're the band. You're not the band, type of thing. And it just reminded me when you said that, I was like, wow, I wonder like could we get that from our judge of like, you know what, these people are Hexico. These people, have the right to, their own financial freedom and not to get their bags fed into oblivion for no particular reason. You can prove these claims. So you guys win. Could it have that effect of so much public support and so many, all the things the communities try to do? You think we have a chance there?
I think you would have. I think it's going to make an impression, whether or not, whether or not it puts. If it's a like, let me just say it this way. Like if it's a close call, and there's one factor that can push it over, you want to have that one factor, right? So this is one factor. I have no idea whether it will have an impact on her or not. None. But I can tell you for a fact that she does not typically talk to full courtrooms. Like, so, this would be something memorable. Like this is going to stay in her head while she's, reviewing stuff and writing the opinion. So.
Got a question or some comments here from Zenith. I like the jurisdictional arguments from the RH team, but worried that the aggressive application of U.S. law is going to overlook the question. It may try to blanket claim jurisdiction. It reminds me of that piece, and then just to add on to that, the stuff that's happened with just people who appear to be, creating services and products and stuff to preserve privacy and freedom and all that stuff. You got Tornado Cash devs getting arrested. You got Telegram CEO getting arrested. All this stuff. Do you feel like, are we able to avoid being just another like, oh well, they just found a way to do it. Like it's not right. It's not correct, but they're just really clamping down on privacy and people who are creating these services and tools for people and stuff like that. Are we like, how much do you think that plays into the how much of a fair shot we're going to get with this?
Yeah, that's a big concern. I mean, if you go back, 30 years ago, prior to when everybody was on the internet, we really didn't have methodology for, when you look at cases that were decided prior to that on jurisdiction, there were distinct efforts like made inside the United States. There were, mailings to people's houses. There were, I don't know, maybe phone calls directly to somebody. There was a bunch of stuff that, now all you do is you put up a website, and the argument is now, well, because everybody on the planet can read it, obviously you're having an impact on citizens of every country in the world. So where does jurisdiction land in that? When can you start exercising jurisdiction over somebody just because they put up a website and people from your country looked at it and acted on something on that site? There's, if I put up an address and said, help me pay my fucking Pacer bill this month because it sucks, and people from, country X, somebody threw me $10. I have no idea where that came from. I can't even tell from the transaction record where that came from. It could have come from New Jersey. It could have come from Oman. I have no idea, right? It could have been from a sanctioned country, that, but I would have no way of knowing that.
Just on that too, like, has there been precedents? It just made me think of like, has there been precedents of other cases where people put up donation addresses and they've received money and, they're like, oh, you can't just receive money on the internet type of thing. Like is there like established, like, yeah, people can just donate to you from wherever around the world, and that's okay. Is that like a point we can make here?
Yeah, I haven't really seen that go anywhere except I think once you swap things into US dollars and use either a if you swap anything into US dollars, you're under US jurisdiction. That's kind of been the DOJ's policy forever, and I think courts just give it to them. Luckily, Richard Hart's smarter than your average bear, right? I mean, he didn't do anything in US dollars. He didn't take any Visa payments or MasterCard payments or American Express payments that went through a US bank and cleared. Everything was done on chain through assets that have no direct link to US dollars. So it stays outside. There's another reason why this would have been a lot easier for the SEC had somebody been able to sacrifice to that address direct from a Visa card that immediately swapped it into crypto and then sent it to that address. That would have been I wouldn't even be talking about this right now. We'd be looking at just moving forward with this case. But Richard did a lot of planning and a lot of smart things when he set these things up. And see, the SEC just believes that if they say it's a security, it's a security. Well, okay. I mean, I guess that's one way to look at stuff, but they keep forgetting that there's a world out there and they're only one part of it. The extra jurisdictional or the extraterritoriality arguments that Richard's making as well are pretty significant. I mean, if Finland wants to regulate stuff that Richard puts out in Finland, if PulseChain launched in Finland, I don't know where to freaking launch from. I have no idea where the servers are when it launched. But if he was putting that information out on a server in Finland about the sacrifice, that's whose jurisdiction is that? It ain't the US SEC's. That's Finland's, right? So if they want to go investigate him, go right ahead. But that doesn't mean the SEC can just grab anybody around the planet just because they use the internet. And that's kind of where we're at.
Quick question from 36 Bravo. Sort of address this. I just want to make sure that it's probably a question that people that's coming up now. Courtroom full of American investors backfire us on lack of jurisdiction.
No, not really. And not really. And there's a number of reasons for that. Like for one, there's, nobody's going to get questioned in that courtroom as to whether or not they're American. Number two, nobody's going to get questioned as to whether or not they sacrificed or bought it, on secondary sales, bought it on Uniswap or, or somewhere. I think if Richard's team was concerned about that, they wouldn't have said try to pack the courtroom. So we're gonna listen to Richard's team on this one because they're the I want to advance whatever their interest is right here. So
they're the best around. No one's ever going to take us down.
Yeah, they're solid. Wow. I mean,
yeah. If you have not seen the thumbnail for this stream, that is the Justice Squad, the 11 top lawyers.
Oh, that's right. That's what it was. Yeah. Okay.
Want to bring up, let's see. Yeah, let's talk about Chevron case real quick. This is something I was talking to you about earlier as well. Yeah. Chevron getting overturned. Can you just explain for everyone just real quick, like what that is and if that would have an impact on SEC, and furthermore, would that have an impact on, this case at all in your opinion?
Okay. Yeah, sure. Chevron was, let me go back to 1984 and I'll try to do this in a short version. There was a principle that came to be known as Chevron deference. And basically what that said is Congress, the way that it works is Congress writes out a, 5-10 page, law that says this agency shall issue regulations to do X, Y, and Z, or to regulate the size of avocado pits or whatever, and so that gets passed in the law goes over to the agency starts figuring out how to make that law happen, and they do it supposedly under the Administrative Procedures Act. There's rulemaking authority. They put out drafts. There's comment periods, all this other stuff that they have to do in order to get a rule in. I hate the APA, and anyway, the less I want to talk about the APA, the better. But essentially, Chevron deference came out because the courts at the time said these people are the experts in the field. So if they think that they have an argument that that Congress gave them the power to do certain things or exercise jurisdiction or issue regulations on a specific thing, we're going to defer to that legal analysis, and that stayed that way for 40 years. And Chevron was a shit decision from the start. The only people that it benefited were agencies who. And Congress, to be honest with you, because Congress didn't have to do the work that they needed to do. They just basically pawned it off on somebody. So when the EPA came up with like the waters of the U.S. rule, which was basically out of freaking nowhere, they just made that shit up and said, we can expand the navigable waters to include the creek running through your property when it rains every other month. And so therefore we can regulate that under the WOTUS rule. Congress was covered because they basically said, well, we didn't do it. That was those guys over there. We didn't write this legislation. Don't look at me. My name's not on that vote for that. So they were covered. They were happy. They got to not do work that they would normally have to do, that they had to do before 1984. And and then there's really no where do you go to complain about a government agency, right? they're just gonna file. There's no help desk over there that gives a shit about anything you have to say. So eventually those agencies kept expanding and expanding and expanding their power, and the courts were starting to see that. And then when you see Loper Bright this year, it was pretty clear that if you give a government agency an inch, they're going to take a mile. And that's what happened. And they just said, okay, well, we're going to put this back to where it was because we can't trust you to play nice with the rules that we gave you. So, and the courts basically said, we're not going to outsource legal decisions because we're the judicial branch and we make legal decisions. So too bad for you. It's all coming back to us. So, I think the downstream impact of that is that, we probably need to start electing smarter people to Congress who know how to write legislation and not just grandstand, because that's really all we have right now. And will it have an effect on Richard's case? I don't think so. And I'll tell you why. Is there's not really any challenge to the SEC's authority over securities. I mean, SEC has clear authority over securities. Right? I mean, we can't really argue that. So the problem is not with whether or not the SEC has the authority to regulate securities. The problem is that the SEC is stretching Howey beyond what its intended purpose was in order to claim that it's a security. But as long as they have the authority to, as long as they have the ability to run in the court and say, hey, this meets the prongs of Howey, so we have control over it. Courts are allowing them to proceed on that basis because the regulatory authority under Howey clearly belongs with the SEC. So I think this is why I've been putting out there, like, we have to get digital asset legislation. We have to, something has to get passed in Congress if you want this nonsense to stop. We've got to have Congress decide who gets control over digital assets, because these are not a straight across, stocks to crypto is not a straight across thing, right? I mean, when's it last, I don't need to, if I have Amazon stock, right? I mean, Amazon's a security, of course, right? It's traded, everything's fine. We got that. Ford, whatever, but I don't need to, as a requirement of having more Ford stock, I don't need to send them a piece of Ford stock. right? Like I don't. If I need to create a block, I need that. I need Pulse to create a block. I need Ethereum to create a block, right? I can't do anything without the gas token. There's nothing similar in securities law. So, I don't think that, I think the SEC right now is taking the position of, let's get as much favorable case law or settlements on the books before somebody actually passes something, so that we can look back at it and say, I don't know, Judge, we've been winning these type of cases for years now. And I think they're just trying to collect as much case law that benefits them as possible before somebody realizes that, in Congress realizes that things need to be changed and need to be defined.
Take a few questions here as well. Some interesting ones in the chat. Zenith asks, would the American legal authority be surprised when Americans show up to a hearing being held on American soil? Seems like catch-22. Yeah, I still don't think it would be much of an effect. I mean, maybe it's this way. Maybe it's like, it's nice to have. Mostly people, if somehow they would be able to know that these people come from 30 different countries to show up, but it's not going to. It'd be more of a positive only instead of like a negative. If it was like only Americans show up, would you frame it that way?
I don't think that it would be positive or negative. I mean, in a 50-person courtroom with, a million addresses on PulseChain, I don't really, tens of thousands of people participated in, in the sacrifices and things like that. I don't really think that's if it was held in Amsterdam and only Americans showed up to the hearing and there was an issue about targeting Americans, I think maybe you'd have an argument there. But like, location on this too, right? I mean, who's the most likely people to show up is people who are interested. And it doesn't even mean that they're all Richard Hart token holders. They could just be interested in some of the issues in this case. Like they want to see how
curious.
Yeah, and they just could, they could be interested in seeing how the SEC argues a specific thing because their attorneys in another case representing another crypto person. That happens a lot too. I mean, sometimes you send a paralegal into a case to see how, to take notes.
Do you think we'll see like a XRP army or other ones come up and be like, what? We don't like the SEC clamping down on people either.
Maybe I wouldn't mind that. Yeah, show up, be like, as long as everybody is presentable, dressed well, professional, and shuts up during the hearing. Like no commentary, no clapping, no sneering at the SEC, no cheering.
Unfortunately, no buy hex signs. You wouldn't want to have a buy hex sign.
No, I don't think I'd recommend that. And then don't forget, I mean, a judge has the ability at any time to clear a courtroom, throw somebody out. Individually, she can throw out the entire courtroom. She can put somebody in if they're disruptive, she can hold them in criminal contempt. So there's good reasons to just go there and watch the movie, and just be quiet. You can keep your mouth shut for two hours during a movie. You can keep your mouth shut for 2 hours during a hearing. So,
Logie 33, isn't it easier to pay a fine and move on, or does it go deeper than that? It brings up a question of, just what is the case for the attorneys just not settling? Like, what is the difference if they settle versus not settling? Like, what are your initial, like your instincts of like, oh, this is, does it change? Like, what does it change one way or another? Like, why is it so important, it seems like, to win this? And they've been putting all the resources to do that.
Yeah. Well, for one, that's a decision that's made by the client. So, have there been numbers thrown out by the SEC? Probably by now. I would think so. I mean, and it's just, if it's cheaper and easier and faster for everybody to go away, the one party's going to throw out stuff and say, just, all right, fine, just give us, whatever, and sign a paper saying that, you won't talk about these securities anymore, or whatever the case is. But I don't think Richard, I don't think that's how Richard wants this to go down. I mean, Richard, he doesn't need the team that he has to make that happen. You can hire literally one dude in New York and achieve that exact same result for a shitload less money. He's doing this because he wants to do this. And, as long as the client has a viable case, which he does, and wants to move forward, which he does, apparently, let's go. I mean, if he wants to win this thing, I'm, 100% behind him, in whatever way he wants to try and win it. And don't forget, like, a fine. I mean, yes, the worst case scenario for Richard in this entire thing anyway is a fine, right? So, I mean, why give it to him early, right? Other than saving yourself a shitload of attorney's fees. But he doesn't want to go that route. I don't think he should need to go that route. I think that's the way the SEC wants to do business, is file a lawsuit, claim that they won because somebody paid a fine, and now they have a gag order on them because the SEC, unlike any other government agency, when you sign a settlement agreement with the SEC, you are not allowed to contradict or challenge or deny any of the claims that were made by the SEC. So if Richard settled with the SEC and paid him $50 as a fine, he would still come with a gag order. So he could never say the SEC was lying about this, and in their complaint, he couldn't challenge that at all. He'd never be able to say that without risking that case being opened back up again. That ain't who Richard is, right? So, I just want to see him. I want to see him go forward.
Isn't it where the SEC too? I mean, it's kind of like, they've been taking some L's from other cases and stuff too. Got a few W's here and there, but it's almost makes me think that that's even a reason that they could want to settle or just drop it or whatever it is, just because this isn't an easy win. Like, it's not set up to be an easy win from what you've seen, right?
It's not set up to be an easy win. This is I don't know that they expected the fight that they have when they filed it. I think if they were expecting the fight, they would have done a better job with the complaint. They would put some effort into it. It's clear that they just basically slapped this thing together and filed it in the hopes that, this guy is living overseas and he's never going to show up, and he's never going to, show up and defend. And we'll either default him and get a fine, or he'll call up and say, I don't want to, what do I do? What do I do to get out of this? But it just didn't go down that way. And here we are.
Question, Vogel. If RH wins, will that open a class suit for compensation claims against the SEC?
No. Short answer. I mean, yeah, I guess there's an argument for it. I see that as such a low percentage chance of having a positive outcome for the people financing that lawsuit, that it's, I don't see that it's viable at all at this point. I mean, if we find out someday that the SEC was outside their mandate, like, let's say, emails emerge that, you have they're an independent agency supposedly, right? So, I mean, if you have them being directed by the White House to do this or something like that, and those emails come out, you can argue that they were acting outside their mandate. And you might have an avenue there to explore. But if the SEC is just doing what the SEC has done for 80 years and saying, this fits the definition of a security in our head, so we're going to sue you for not registering that security and then issuing it without, going through the, all the brain damage you have to do with normal issues of securities. I don't see it would be a viable suit without some additional information.
Gotcha. One more question before we move on. What's the likelihood that SEC doesn't care about having a coherent case? What's the likelihood that SEC just another corrupt extra constitutional entity that sees a bag and wants to grab it? Yeah, it's kind of what we play into too. Like, is it just a numbers game? Do they just want to get as many wins as they can as easily as possible to set up some precedent before regulation comes in? Is that kind of like, again, good for us?
I think, and I said it. I think I tweeted this. I'm not sure. I don't remember when I say things or to who, but when's the best time to go after somebody? Like, I mean, if I wanted to kill the software operating industry, like if I wanted to kill the automotive industry, the best time would have been do it before Henry Ford released the Model T, right? I mean, because after that he had the money to fight back. When do you go after cryptos? Before the market matures, before people adopt. If you wanted to go after the internet and shut the internet down, like if you wanted to outlaw ISPs or something like that, you had to do it well before they started making tons and tons and tons of money, because that's when you can bankrupt somebody. You can't bankrupt somebody who's like Bill Gates. You can't bankrupt somebody like the Ford Motor Company, really, with a lawsuit like this. I mean, Boeing pays a $250 million fine or something like that. It doesn't even show up on their balance sheet, right? But you can bankrupt small organizations. The library went bankrupt fighting the SEC, right? Did they do anything wrong? I don't know, probably not. But that's not the point. The point is to choke it out, choke this baby in its crib. And I just don't see. I don't think that they expected. Maybe they didn't expect Richard to actually have the money that Richard had. Maybe they thought it was all his money was from the sacrifice, and he didn't really have. He wasn't really independently wealthy or something. I don't know.
They have been watching his streams for years, and just him talk about his life story like 50 times about 150 employees and being rich before crypto and buying Bitcoin at $30, writing one down to $1. All the greatest hits. I'm pretty sure he's rich. Pretty sure.
Yeah, I mean, and that's what makes it so silly too. He spent $12 million of investor money, whatever. First of all, I would be shocked if he actually spent investor money on that. Like, and I'm going to call it investor money, even though only because the SEC uses that term. We were just sacrificer money, right? So, but I would be shocked if we could directly trace those dollars to those items. And I don't think the SEC can do it. I think they need to get past the summary judge, or the motion to dismiss, in order to get into discovery, and then they can start asking those type of questions. But if I was on Richard's team, I would already know this answer. I would have known this answer from day one, right? Because if I could, if I know where those transactions went, that's information that tells me, whether or not the SEC's case is viable. It's not the right time to bring that up, I don't think, but I would certainly want that in my pocket for later on. If I could absolutely 100% prove that the SEC's fraud claim is full of shit, I would 100% be ready to pull that out of my pocket at any time.
Just going through one of your law school posts as well. We were talking about this one. So amazing. Again, cannot thank you enough for like doing these huge write-ups with all the commentary and stuff. Let's give everyone in the chat just clap real quick for Nicholas.
Thanks, guys. I enjoy doing it. So
3 to 6 to 9 more seconds. All right, thank you again, Nobleman. Appreciate you and what you do in Hexco. Anything that you want to point out? We'll wrap up here in a few minutes, but anything that you want to point out or summarize or otherwise talk about? Again, there's only one. Again, I guess the first time I put it like this, but there's only one valid expectation. Hexco, we will win. Victory. Why is do we have any good karma on our side? Do we have any? We got plenty of facts. We got plenty of exhibits. We got plenty of high-paid lawyers and all this stuff. We got RH, to win. But anything that you've seen recently where you're like, man, that is cool. I like that. Like that is something that I think people are not even talking a lot about.
Not particularly. I'm just gonna, I was impressed with his team basically tearing apart stuff that the SEC was relying on and not having to walk back a single thing in their arguments. What a great job you did, or Richard's team did from the outset, to put something in there so completely bulletproof that they didn't have to change anything in their reply brief. All they had to do is just reiterate, hey, we told you this before, we're sticking with it. You tend to notice those things as a lawyer as you read, your 1 millionth brief or whatever. You tend to notice tone. You notice, who's being petty in briefs. Like why would you need to point out price in a jurisdiction brief, right? The SEC did that twice. What are you doing? It has no relationship whatsoever to jurisdiction. All you're doing is you're trying to get under his skin. And, and Richard's team handled it like they should have handled it. They ignored it completely because that's not relevant. Just stay on target, like I'm headed into the Death Star. Stay on target. So, and I guess I'll just say too, like, please don't, no matter what happens with the ruling in this case, this is the earliest possible stage of this case. I mean, Richard hasn't even filed an answer yet, which is this, that usually happens within 20 days of a complaint, right? So don't get too up if you win, don't get too down if you lose. Losing this doesn't really mean anything other than the SEC now has to go prove everything it said. That's all it means. I'm hoping that it gets short-circuited by dismissing it on jurisdiction, but if it doesn't happen, it doesn't happen. But Richard's team is pretty well prepared to go argue this thing on its merits. And I think I'm not sure that could be any clearer.
Yeah, that's so what is the timeline then? I mean, we talked about, we started the stream 6-7 weeks until October, oral arguments, and then we should know how long after that before, if it gets dismissed or not. How long do you think it'll take?
Yeah, that'll be the target range you're looking for there. The middle of the bell curve is between 60 and 90 days afterwards. And that's because, the judge is going to go back, and, even if she knows the minute she leaves the bench who she's ruling for, she's not going to tell anybody right then. She's going to go write an opinion and bulletproof it because she knows that one side or the other could take this up on appeal, and she wants it to be upheld, whatever her decision is. So it's going to take her some time to go put that down on paper. If she only has to decide the jurisdiction issue, and like if she finds that there's no personal jurisdiction over Richard, then she doesn't have to decide anything else. Any of the other arguments that are made that day won't make a difference. So that one situation, I could see that brief or that decision coming out, in that 40 to 50 day time frame, like earlier, like right before Christmas time frame, because that's a much easier one to write because you're only dealing with one issue. You just ignore the rest. So I'm not saying that I'm not saying you'll be able to tell anything. Like if it doesn't come out before Christmas, obviously he didn't win. No, you can't ever tell. It's like the old joke with lawyers. Like is the jury being out longer good or bad for my client? Yes. There's just no way to tell, right? Judges do what judges do. It could be that could be that she spent 2 weeks in Mexico and is just getting back to it now,
People do that. People spend multiple weeks in Mexico on vacation. I've heard of that.
Yeah, it happens. So, but please don't. Whatever happens, it's not the end of the world in either direction. It's not the greatest thing in the world. It's not the worst thing in the world. So,
so if it doesn't, if motion is dismissed, ends up getting denied, worst case there, then 2025, we go into 2025, and they start, what happens there? They just start, arguing based on merit, and
yeah, they'll go through discovery and then try to. What this case will be decided on summary judgment if it doesn't get decided on the motion to dismiss. This is not a trial case. Nobody's going to trial in this case. This is a summary judgment motion type case, because there's not going to be any what we call material facts in dispute. It's the facts of issuance, the facts of what somebody did. You're not going to go back and change them at this point. He said what he said when he said it. It's just a matter of whether or not we can tell when things were issued on certain days because it's all on chain, right? So we can tell what money came in, went where. None of this stuff is a fact that needs to be found by a jury. So this is a summary judgment case. And my best guess, if everything moves forward and the SEC doesn't have to rewrite their fraud claim and come back with a new complaint and all this other shit, if everything just goes straight forward from here, I would say third quarter, fourth quarter next year, you're looking at the parties filing motions for summary judgment, probably cross motions for summary judgment. And that will be on a more expedited, or at least I would think it'd be on a more expedited briefing schedule, not this 3 month shit. That would probably be, at the most, I think you'd probably have that thing briefed up in, a month and a half, 2 months, and then a hearing probably again sometime around this time next year. So.
And we've seen, so next year that, and then, a lot of people think bull run could have the top of the bull run maybe next year if there's a 4-year cycle deal, different, speculation out there too. But the fact that this case is ongoing, there's been on-chain moves of sacrifice funds and related, all that stuff too. That seems unchanged, right? It seems like not affected. SAC funds not affected. Richard's finances in general.
Yeah, I don't think it's connected. First of all, the chain works. Richard's not running validators because he exited them all, right? This thing is entirely decentralized. He couldn't stop it if he wanted to. He doesn't have any control over, who creates blocks or does what on the chain. This is, he basically just wound up the toy and sent it on its way, and now it's just walking down the street. It's just up to everybody else to make the thing work. He gave us a working engine, and it's our job to build the car on top of it, and that's what everybody's doing. The good news is that the thing works perfectly. Right? When Solana didn't work perfectly, other chains get taken down, on a regular basis. This thing's been running perfectly for how long now? A year and 4 months or whatever the hell it is. I don't even know what month it is.
May 12th, May 13th. Coming up on a year and a half or so.
So, whether or not, if Richard, died in a plane crash tomorrow, is this chain going to continue, or is everybody going to just, cry and, talk about how much this investment sucks?
That would be sad. They're probably crying for many reasons, but right.
But it wouldn't. Does it have an effect on the ability of the chain to create blocks from now until eternity? No.
Validators do not go down because of that. The community does not dissipate. I would say, just in the scenario where, the devs disappear, which disappear, all that stuff. Great chain, lots of projects that have invested in it, did stuff on it. Of course, what if Vitalik disappeared? Would Ethereum still feel the same?
Right.
But it's like things are still working. We don't, he's not out there pressing buttons to make the blocks go through. That I think is your point.
Right. That is. So whether or not Richard walks away from this, with a fine or walks away from a clean or whatever, should have no effect on, whether or not people use the chain, I guess is a good way to say it. So the only thing might have an issue over is whether or not centralized exchanges want to list something that the SEC calls a security and has jurisdiction over. That's the only issue.
Well, apparently Coinbase don't give an F because they were like, they got the Wells notice and stuff. And they're like, yeah, we're not going to stop doing this stuff. We're not going to stop listing stuff just because arbitrary says those type of things. So
yeah, and as much as I can't stand Coinbase as an entity, I kind of respect their legal team for taking that position.
Definitely.
I'm rooting for them to win and then immediately go out of business.
And all our customers come to PulseChain and all of our services and DeFi would provide.
Yeah. Well, I have personal reasons for that. It has nothing to do with Coinbase. Like, it has everything to do with Coinbase, but it's personal, not legal.
Well, Nuclear Herbs, just no legal advice or anything, but do you think we will win?
I think that this is a much harder case for the SEC to win than many of the other ones that they've taken scalps on. So I don't like to make predictions, but if I was going to go to battle in a case like this, I'm going to feel pretty good with the team that I got. If I'm Richard, I like it. I like his arguments. I like his legal position. I think that he did so many things correctly, or with the absolute intent of not getting trapped into Howey, which you're allowed to do. I'm allowed to create, if the law says you can't do X, Y, and Z, and I do, A, B, and C instead, I'm allowed to do that. I'm not being prohibited from doing A, B, and C. It's just that the SEC is like, well, you know what? We're taking over A, B, and C too. I'm like, come on, man. That's where we are, really. It's just the SEC is going outside of what Howey was intended for, and saying and applying it to all kinds of digital assets. And that's going to work right up until it doesn't. And I'm hoping that this is the case where it doesn't.
Awesome. Well, like I said, I fully expect a victory in one sense or another. I hope we get this wrapped up sooner rather than later. And but either way, chain's working, communities here, and we've been surviving. Hopefully we'll be thriving. Hopefully bull run. Hopefully number go up. All that good stuff. Nuclear Herbs, where can people find you and hear more about your amazing commentary and dedication to PulseChain Law School and our community?
Yeah, the only place you'll find me is Nuclear Herbs on Twitter. That's it. So
Nuclear Herbs on Twitter.
Nobody knows where I live. Nobody knows where only my wife.
Yeah. Well, yeah. Hopefully. Well, yeah. As Richard would say, there's no benefit to all of that stuff. So he's got a lot of smart sayings. Shout out to Richard Hart, by the way. Shout out.
Absolutely.
Got this guy here. Boom. Shout out to Richard. Been a while. Hope to see you back streaming or just producing a video from time to time. We do enjoy the audio and video non-live sessions as well. So feel free. Anyways, that's all we got for you today, everyone. Hope you got your money's worth. $0 worth. All Nuclear Herbs if you want to get some more PulseChain updates and all the legal commentary and all that stuff. Really fun. And Scivive and 5555. We are out.
Thanks,